Welcome back. I hope you all have been enjoying lunch. You clearly are still enjoying lunch. Our next conversation we are calling The Importance of Institutions. As we were designing the day, we kept coming back to these fundamental principle of rule of law and how critically it undergirds our democracy and really enables it. And I can't think of a better group to take up this topic than the one you are about to hear now. Kettering Senior Fellow Neal Katyal, former acting Solicitor General of the United States, who has argued over 50 cases before the Supreme Court, more cases than any minority attorney, having beaten Thurgood Marshall's record. As if that were not enough, he has also appeared in House of Cards and Billions as himself. I want to do that. Another Kettering Senior Fellow, Judge J. Michael Luttig. He's one of the most important legal scholars today, a renowned conservative jurist, clerked for Judge Antonin Scalia, served in the Reagan White House, Assistant Attorney General, served on the U.S. Court of Appeals Fourth Circuit bench for 15 years, and was on the short list for nomination to the U.S. Supreme Court. These two will be led in conversation by the amazing Melissa Murray, professor at NYU Law, co-author of the best-selling new book, The Trump Indictments. Please read it. Former law clerk to then U.S. Court of Appeals Judge Sonia Sotomayor, co-host of the hugely popular Supreme Court podcast, Who Thought There Would Be One?, Strict Scrutiny, and a legal analyst for MSNBC. I can't wait to hear from these three. Please come on up and get ready to enjoy yourselves.
Thank you so much for having us. We know we're right in the middle of dessert, so we'll try and make this as amusing and amuse-bouche as possible. I will also say, the first panel was such a delight for me as a constitutional law professor, because I know you know these speakers as Governor Sebelius and Governor Whitman, but I know them as the other side of NFIB versus Sebelius and American Trucking Association versus Whitman. So very exciting to see them in the flesh today. My students are going to be so jealous. So the topic of conversation is the importance of institutions, and we've heard a lot of discussion about the term democracy today. And so, like any good law professor, I want to go back to the beginning. Right, so the origins of the term democracy come from ancient Greece, the classical period, and Athens was the birthplace of democracy. But notably, what made Athens so distinctive was that it was a relatively homogeneous society. The Athenians looked alike, they had a common set of institutions, they had a common set of values, and that kind of homogeneity allowed democracy to really flourish. That is very different from what we are trying to do here in the United States today. And so I guess the first question I'll ask you first, Neal, can a multi-faith, multiracial, pluralistic society sustain democracy?
So the answer to that, I think, is yes. But before getting to the answer, I just want to thank you and Kettering for the opportunity to be here. And it's so rare I get to appear with Judge Luttig, but I just have to say what an honor it is. Judge, when I was in law school in 1994, I did not apply to clerk for you. I was scared of you. When I clerked for Justice Breyer, the clerks you sent up to clerk at the court were Ted Cruz and John Eastman.
That's what we call a backhanded compliment.
Well, let me get to the compliment part, because what I've seen you do on January 6th, and frankly, every day since, sometimes I despair about where the country is, and then I think of you and what you are doing and standing up for in your bravery. And it's, my parents came here from another country. They didn't know what the Constitution was, but they certainly knew what the rule of law was, and you are the embodiment of the rule of law.
Talk about the Athenians now, after that.
So on the Athenians, I go back to Madison and Federalist 10 and 51, which I think is right. The because central insight of the founders is the pluralistic, divergent society is actually one that is stronger and more resilient. That because you have so many different factions, you can't have one overarching faction. Now, social media and modern political parties is certainly a challenge to that. But I do think, I don't want to overreact to Trump and Trumpism and MAGA, because I do think that is the core of what America is, and somehow institutions like this need to rebuild and strengthen that core.
Judge Luttig, do you agree? Can we, as a multi-faith, pluralistic society, construct a common core that can sustain democracy?
Maybe. Thank you, Melissa. Neal, thank you. And thank you, Kettering, for having me here today. One word of disclaimer. Everything that I say in front of a camera, whether it's right or wrong, I attribute it to Judy Woodruff, the great. A digression just to begin. So Judy, for some reason unknown to anybody, wanted to interview me and out at our house in Vail. And so she landed in Vail and took over my house for 2 days. And we finally got to the moment, and I'm sitting in my own house, and I'm about this far from Judy Woodruff. And we'd all been made up and everything ready, and she says, "Judge, are you ready?" And I said, "No." And she said, "Well, what's wrong?" And I said, "Well, I need to take just a moment to compose myself." I said, "You have to understand, Judy, from my perspective, I'm sitting in my own home about to be interviewed by Judy Woodruff. But this will take some time. I'll get back to you as soon as I can." No, I want to start at the beginning, which was January 6, 2021. I testified in front of the House Select Committee 2 years ago in June. And the first line of that testimony was something to the effect that a stake was driven through the heart of America's democracy on January 6, 2021, and today America's democracy is teetering on a knife's edge. I went on in that testimony to say a lot of things, but I also said that Donald Trump and his allies and supporters were that day, only 2 years ago, in plain view of the American public, preparing to overturn this coming election if they concluded such was necessary. And this morning someone sent me an article from the Washington Post. I don't know if it was this morning or yesterday. It was actually from my 94-year-old mother-in-law who lives on an abandoned island in the San Juans. And so she sent me the article around 3 o'clock her time, a.m. And it was the Washington Post article that I'm sure many of you read that quoted and described the fact that the former president and now all of those who are vying to be his vice presidential candidate have now said publicly that they will not necessarily accept the next election, and it will depend on whether they won the election or not. So that's 2 years after I told the Congress of the United States that that's exactly what they were preparing to do in plain view. So beginning on January 6, 2021, but more importantly, today, Donald Trump and his supporters are holding America and America's democracy hostage. There's just no other way to frame it. And I say it that way. First off, remember, I'm a former judge, so I only do fact and law. That's the case as a matter of fact and also law. Much of the discussion this morning and much of the discussion for the past 3.5 years, as you know, has been as if both political parties, certainly, but all of us are facing the most significant threat literally to America's democracy because all of us have failed. That's just not true. We are where we are today because of one man and now one of our two political parties. They have, as I said in my testimony on January 6th, they instigated a war on America's democracy. And I said then that some number of those who instigated that war with the former president were determined to see that war through to its catastrophic end. That's where I believe we are today.
So I take from your remarks that you would view Donald Trump as perhaps the most profound threat to American democracy today. Is that a fair statement?
That would be an understatement. 2 years ago.
Trying to be even-handed here.
That may be the problem. We're here gathered to talk about democracy, and we're asserting profoundly that it's nonpartisan. And that's true. But those who oppose American democracy today, they regard democracy as anything but nonpartisan. It is highly partisan, and it is highly political. And the evidence abounds, but I would just point out that, as I have of late, the intellectual underpinnings of this movement on the far right, intellectual, these are some of the most thoughtful, most brilliant thinkers and writers, and they are talking about literally a revolution exactly like this country had, almost 250 years ago. And there's no, whatever the phrase is, there's no fuzz on that orange, okay? That's what they are saying is needed to return America to we the people.
So with that in mind, Neal,
Let me say, just in case anyone thinks differently, okay? The Democrats are responsible for a lot of bad stuff. They're not responsible for this fundamental assault on America's democracy for the first time in American history.
Right, so January 6th is this major inflection point. There's no going back from this moment, and it's a profound moment, one that I think you would rightly say demands accountability. Right now, there are 4 pending indictments against Donald Trump. 2 of them are directly for the events that gave rise to January 6th. They are unlikely to go forward before the election. We are unlikely to see any kind of resolution in those cases before the election. Neal, is this a failure of our institutions, or is this just evidence of how fragile our institutions have become?
Yes to both. So, the Georgia case, as of yesterday, is now going to be put back for the Court of Appeals to decide the disqualification motion of Fani Willis. That is almost certainly cannot happen before the November election. The Mar-a-Lago case, which is like an open and shut, easy criminal case, is delayed because of pretrial proceedings by Judge Eileen Cannon, and then the January 6th federal one. The Supreme Court had oral argument a couple weeks ago on whether Trump is absolutely immune. this I didn't think was a thing, but they did have, a pretty, rollicking argument there. That there's some possibility that case can go forward. I disagree a little bit with all the pessimistic analysis. I think the Supreme Court could decide this in June in a way that would allow the trial
What would
to
that
proceed.
look like? Because I've been one of the pessimists here.
Yeah, so I don't think they're going to say that there's no immunity whatsoever. I think they will say for some zone of official acts, and Michael Dreeben, who's arguing for Jack Smith, I think made that clear, and leave that a little bit to the district court, but with enough guidance to say, look, here we've got an indictment. There's some stuff that's core private acts, as even Trump's lawyer admitted. There's some stuff that isn't, and then it'll also be up to Jack Smith to see how much he wants to pare down the indictment. At the oral argument, he was almost given the opportunity, Dreeben was, to pare it down because Trump conceded there were at least 3 key acts that were all fully private.
And the private acts are the ones that would be outside the scope of any
Correct.
immunity.
Yeah, thank you. And Dreeben didn't take the court up on that, but I think that may just be because he didn't have authority to do that. Yes, he was sitting next to Jack Smith, but Jack Smith may not even have authority to pare down the indictment. He may need to go to the Attorney General under the special counsel guidelines. So all a long way of saying, I think there is a possibility that this could happen. I do think that it does demonstrate that our courts, we haven't been focusing as much on who gets on the courts. And some of these decisions I find inexplicable. And I don't know whether you call that a failure of the institution or a failure of personnel or what, but some of these people are not acting like judges. I would just think, I think back to Bush versus Gore, on which I was a junior lawyer, 36 days start to finish. 2 different times we went up to the Supreme Court. Courts are capable of acting more quickly, and here you've got a monumental election, you've got a major candidate accused of crimes, and yet the American people aren't going to find anything out about this.
Well, interestingly, the Supreme Court did move with a spirit of urgency and expedition with regard to Trump versus Anderson, the Colorado disqualification case. So I know you, Judge Luttig, filed an amicus brief there about the scope and substance of Section 3 of the 14th Amendment, which Colorado argued disqualified Donald Trump from its ballot. And the court moved relatively quickly to decide that issue. And it ruled that Colorado did not have the authority to disqualify Donald Trump, that in fact only Congress, through congressional legislation, could take steps to enforce Section 3 of the 14th Amendment. Was that the right decision?
Well, they didn't make a decision at all, Professor. But on the larger question, at arguably the most important moment in American history, when the country has needed the Supreme Court most, it's failed. It's failed the Constitution and it's failed the country. It's now clear, and I can say confidently, the Supreme Court's never going to decide any of these issues, ever. They didn't decide them when they were put in front of them, and they're never going to decide them. On the 14th Amendment issue, the so-called opinion was an embarrassment. It's one of the most important cases ever argued in American history. I don't even know what you call the opinion. They called it a per curiam. Arguably, sort of, there were 3 dissents from that. If you define dissent as someone who says the most, biting things that you could say about an opinion that you join. I'd spend the whole afternoon if you'd like to.
All right, we have 15 more minutes. So I'm really interested to hear both of your thoughts about this as avid court watchers. So in this per curiam opinion, the court professed to unanimously determine that Donald Trump could not be disqualified by the state of Colorado from its ballot, that only Congress could do that. There was a separate writing by Justices Kagan, Sotomayor, and Jackson, which said it was a concurrence. It was concurring in the judgment. But as you say, it read very much like a dissent. And it was more pointed and sharp than any separate writing I've seen in a really long time. At 4 points in this separate writing, Justices Sotomayor, Kagan, and Jackson referred to Donald Trump as a quote-unquote oath-breaking insurrectionist, and at one point they noted that their colleagues in the majority had taken the liberty of sequestering this issue and the court from this broader question of the scope and substance of the 14th Amendment for the purpose of secluding this defendant from it, which to me sort of read like our colleagues are in the bag for Donald Trump. Is that how you read it?
Well, you don't have to go to the argument, but first I want to make the point for our audience that the argument in the 14th Amendment disqualification case was 3.5 hours. Very precious little of that discussion ever discussed the issue in front of the court. From the second argument began until the last minute, I knew to an absolute certainty that the court would never decide the issue. And of course it didn't. Fast forward to the absolute immunity case. Absolute immunity case. As Neal said, I mean, this is like no one in 250 years has ever even thought to make the argument, much less had the courage to make the argument. And the Supreme Court was receptive to that argument. But in that argument too, almost no single question was asked about the only issue in front of the Supreme Court. In that case, in 2.5 hours, there was only one issue in front of the Supreme Court of the United States. One issue. Whether the former president could be prosecuted for attempting to overturn the 2020 presidential election, remaining in power, notwithstanding the vote and will of the American people, preventing for the first time in American history the peaceful transfer of power. Mark my words, there was hardly one single question. As I said, I was on Nicole Wallace. Judy Woodruff, again, is at fault. And I was to be on there for 40 minutes talking about everything but this issue. And 55 seconds in, she turns to me and says, Judge, the Supreme Court just took the absolute immunity case. What are your thoughts? And I took a moment and I said, there's not a reason in this world for the Supreme Court to have taken the case, but it's almost a certainty at this point that the court, that Donald Trump will never be tried before the election, and I doubted if he would ever be tried. The court immediately set the case for argument 2 months from then. In the last week of argument, there's not a chance in this world that the Supreme Court will decide that case by the last day of the term. The trial judge had already committed to 88 days for the former president to have a fair trial. If they decided at the last day, and if everything else went perfectly, that trial would begin the first week in October, 3 weeks before. But now the court hears the case, doesn't discuss it. What do they discuss? They discuss, well, did he take these acts, the charged acts, in his official capacity as President of the United States, or in his private, personal capacity? I can tell you, under the law for 250 years and under the Constitution of the United States of America, it's utterly irrelevant. And the Supreme Court was up there flailing around, asking the poor attorneys, well, what do you think the difference is between his official acts and his personal acts? And Dreeben, who's one of the greatest advocates of our time, second only to Neal Katyal, Dreeben's sitting there in his mind, the thought bubbles they call it. He's going, what are you even talking about? This is one of the gravest offenses against the United States of America that could ever be committed by a sitting president other than perhaps treason. our Supreme Court of the United States is sitting there twiddling its thumbs, knowingly delaying his trial until after the election, and then they're going to send it back to the trial judge who has no clue what they're talking about, and they're going to ask her to decide which of these acts did he commit in his official capacity as President of the United States and which in his personal capacity.
So I've got you really wound up. So Neal, I want you to interject here.
I sure am.
Just a couple things. One is I was actually at the argument, and I agree, Judge, with what you're saying about the overall tenor of the argument. I will say that Dreeben, and it was an hour and 55 minutes into the argument at 11:55, did explain what Trump was accused of in the indictment and what he did to the Justice Department in particular, pressuring them to try and send letters to the state legislatures saying there was election fraud, and then threatening to fire those Justice Department employees who refused to send the letter. And at that moment, you could hear a pin drop in the courtroom. Every justice was paying serious attention. And I think, you know, one of the problems we have here is that Americans don't get to see the court, so you just have to take my word for it.
No, they can listen.
But listening, you don't get actually what the dynamics were in the courtroom. You don't get, for example, that when Justice Sotomayor asked early on to Trump's lawyer, you know, counsel in the Court of Appeals, you said the president could send out Navy SEAL Team 6 and it wouldn't be a crime. Do you stand by that? The lawyer says yes, and you see Justice Barrett go open eyes like this. I mean, there are things that you are really missing with this, without the ability of the American public to see it through cameras. With respect to your question about the dissents and the rhetoric and so on, I guess I have a different view. First of all, this is a court that is name-calling a lot. Think about Justice Kagan and what she said about your former boss, Justice Sotomayor, in the Andy Warhol case.
But that was a copyright case.
But it's like you know, it's the equivalent of, you know, Justice Scalia's line about putting a paper bag over your head if you wrote that opinion. So, you know, one is I think there's just some sharpness on the court. The second is maybe the three more liberal justices do have that view, but I don't think that they'd want to deploy that and be too express about it. After all, sometimes this court has rendered decisions against Trump. You think back to the 2020 election, the 62 different cases, some of those went to the Supreme Court. They were all denied. Think about the executive privilege case in which the January 6th committee pierced executive privilege, 8-1 decision with only Clarence Thomas dissenting, siding with Trump. So there are instances of the court being able to act impartially and against Trump, and I suspect that the three on the court are trying to make sure that, you know, that they haven't antagonized things, so that's impossible as we go into the 2024 election.
So let me just say, so Neal, as we've established, is currently an advocate in front of the Supreme Court. I'm not. And the other difference between us is I have life tenure and he doesn't.
No, I'm at Georgetown, man. I got tenure. In fact, I think you resigned your life tenure.
Neal has many jobs, so it'll be
okay. But look, of course what Neal says is right about the argument, but twice before, when Dreeben had tried to make a point about the actual case pending in front of the court. By the way, this is the Supreme Court of the United States. It's not like some county courthouse, right? And so, you know, when Neal says, you know, Dreeben finally got to tell the Supreme Court of the United States what the former president was charged with, just think about that. And I'm willing to accept that that's what was going on. They didn't have a clue until Dreeben said it, but only for sake of this conversation. But twice before, when the court had asked, Dreeben was trying to argue his case, the court literally had said, I'm not interested in the facts of this case. Quote, I'm asking you about your argument that a president could order his political opponent assassinated and could never be held accountable for it. Now, there's no reason in the world you guys should know anything about the judicial process, but it was unbelievable. Mm-hmm. What you do know is courts decide only the issue in front of it. And that whole argument was about, as I said to Nicole that day, it was about every other issue except the
So,
issue.
Judge, I just have to say, I disagree. I mean, I think almost all of my arguments at the Supreme Court they will say, this isn't about this case. They're testing the limits and logic of your position for every other case. I think that is what the job of the Supreme Court is.
I'm going to jump in to defend Judge Luttig here. I think he's right. They are arguing about everything but the issue because they changed the issue in the questions they accepted for review. So yes, the initial question that was put on cert after the discussion in the DC Circuit was whether a president could be absolutely immune. And it's the court itself in granting cert that changed the parameters of the question to specifically probe this question of private versus public actions, which gets us here. So that's, again, another layer of this. My question for Neal, though, is going back to this idea of public participation. Like you've talked about democracy, the people are an inherent part of a democracy. Right now, we're all talking about the courts as if the courts are the last stand, the last bulwark available to check excesses of government power, whether it's the president or Congress or something else. Does it matter that our highest court is so removed from the people? I mean, you've already mentioned the fact that we haven't really made the court a part of progressive politics. That is changing, but it's been a very slow change. You've mentioned the fact that most Americans don't engage with the work of the Supreme Court and certainly the lower federal courts to any degree. Most Americans only know of courts through things like the People's Court or Judge Judy. I mean, is that a failing of our civic culture in the way we talk about courts?
100% it is, and it may have worked back in an earlier time when the court wasn't so interjected into every facet of our political, social, private lives. But now it is, and it's a court that is very much out of step with mainstream America. And so, I do blame the Democrats for that, for 50 years, for neglecting the courts, for talking about other stuff. Whereas the Republicans had a very concerted strategy. It may be because they lost Roe in 73 and were galvanized by it, I don't know. But for whatever reason, you now have a system and a system of courts that is very lopsided. And I wouldn't say it's just in terms of numbers. I would say it's also in terms of intellectual firepower. I mean, if I took a list out in 2020 of the 15 or 30 most prominent intellectual conservatives, many of them now are on the Court of Appeals that Trump put on. And I wouldn't say that about Biden or Clinton or Obama. And so there is a mismatch. And there's just a lack of attention that Dobbs is starting to change that, but we have a lot to do.
So another element of this, you mentioned the introduction of movement conservatives to the judiciary. A lot of that happened through the Federalist Society and sort of the network of conservative groups within the conservative legal movement. How much does the influx of money, and quite a lot of money, change the nature of our politics and distort our understanding of democracy? Judge Luttig?
Well, I hate to cause problems here.
You've been spicy all afternoon, so I'm not surprised.
But look, what I do want to say is this. I was on a panel a few days ago with a dear friend, an academic, wonderful, brilliant academic, and we were talking about these very issues, same issues. And she was telling the assembled crowd that, and this was her metaphor that she probably wishes she had not used, but she said, look, the house is burning down, and we've got to renovate the house right now. Well, for a non-academic, that was like manna from heaven, right? So when it came back to me, I said, well, I'm just a regular guy. I'm not an academic. The house is burning. All I know I'm smart enough to do is go get water and put out the fire. And I said, and then we can turn the renovation of democracy and the rule of law over to the academics. That's a little bit of what I'm feeling, what I want to say today. In other words, the house is burning. it's going to burn to the ground in the next 6 or 7 months or not. The immediate task is to stop the house from burning to the ground. And if we succeed in that, then we can talk about how to renovate whatever's left of the house. But on the Supreme Court too, it's like, you know, I know I've got distinct views on what's going on in the Supreme Court, but it doesn't matter. They've told us they're not going to decide the cases, period. So there's no need waiting for the Supreme Court. They have failed us. We've got to go out and try to save this democracy against the onslaught.
So one thing that's actually quite encouraging, and I would say for American women, it seemed very clear that the House was on fire in June of 2022 when this Supreme Court, in a supermajority, upheld a Mississippi law that banned abortion at 15 weeks, and then by a 5-4 vote overruled Roe versus Wade and Planned Parenthood versus Casey, both of which had extended and confirmed the right to an abortion. We saw almost immediately a galvanizing of democratic engagement around the question of abortion, and it's proven to be very potent in terms of turning individuals out at the polls in ballot initiatives, but we've also seen a real fear of democracy, which is ironic because the court's decision in Dobbs professed to return the question of abortion to the states and to the people for democratic deliberation. Now that that deliberation is happening, but it's not proceeding in the direction that Justice Alito had imagined, we suddenly have all of these efforts to limit democratic engagement. So efforts to limit ballot initiatives, efforts to cut down the scope of certain ballot initiatives that can be put before the voters. Neal, what do you make of all of this? For the first time, the American public saw a right that they had been born with withdrawn.
Yeah, it's such a great question. So, I mean, I guess I start with the idea that what Alito said, political engagement and so on is the solution. It's not playing out that way. And so you have not just the ballot initiative and stuff, but even litigation strategies. We have the mifepristone case, which is now pending at the Supreme Court, in which conservatives went and sued the FDA, which had approved this abortion drug been approved since the year 2000, and said, you can't do that. That would just totally topple our entire system of pharmaceutical regulation if this lawsuit were allowed to proceed. And that's an example of the political branches doing what Alito said they were supposed to do, and yet now you have the conservatives coming in and saying, oh no, you can't actually do that. We didn't mean that. That should be off the table. That happens time and again. And I agree that, oh, by the way, and I think mifepristone, we will likely win this case, and I think that'll complicate, unfortunately, the electoral dynamics you're talking about, because the headlines will read, Supreme Court stands up for abortion rights, or something like that, right before the 2024 election, as it happens to be. So I do think it's a complicated thing. I think the thing about your question that I struggle with is that, yes, we have this Dobbs moment, but we haven't had this moment in other things. Like I argued the Voting Rights Act case right after President Obama was sworn into office, the constitutionality of the Voting Rights Act at the Supreme Court. And I remember, it was just an incredibly terrifying thing to have this sacred act and have to defend it. And I remember when we won, John Roberts said in the opinion, may reconsider this at some point, but, for now, this is the law of the land. And then he goes and reconsiders it, as you know better than anyone, in Shelby County, 5-4 decision to strike down this canonical act, which has, frankly, the blood of patriots on its pages. And what was the reaction to that? I mean, Justice Ginsburg wrote a great dissent, but there's no public reaction. I mean, when I argued the case in 2011, Justice Scalia asked, he said, what was the vote in Congress to reauthorize this act in 2006? It was 421-3 in the House and 98-0 in the Senate. You don't have that constituency anymore for the Voting Rights Act, for the ability of people to vote. Something deeply rotten has happened in our politics, and unfortunately, the political channels don't seem to be grabbing hold of that.
So can I come back to that? Like in the last conversation between Brad and Sarah, Sarah mentioned that there seems to be a divide about what we think are the core things that America's about, the things that America does well. And we all know what America does well. Do we all know that? I mean, that is, as I was listening, that was something that I wonder. I think some people have an idea of what America is good at, and I think it's fundamentally different from what other people may think. And your response about the Voting Rights Act, I think, taps into this. Do we have two fundamentally different ideas about what American democracy looks like for different groups of people?
Well, of course we do. I mean, right, if your African-American democracy didn't mean much to you for a long period of time, it doesn't mean the same thing as it does to other folks. But I do think we do have a common set of goals, and not goals like the Soviet Constitution, like aspirational crazy stuff, but stuff that is often achievable, maybe not for everyone, but for some people, and the goal is to try and expand that out to make it available to all. I do think that's the DNA of what our country is. It's the founder's vision. It's the vision of every immigrant who comes here, like my parents. And I do think, I don't want to give up on that, and I don't want to toss it out. So I want to fight for it the way that Judge Luttig is talking about.
Professor, we for 250 years we had shared views of all the values and principles on which this country was founded, and on the basis of which it had become the beacon of freedom and democracy to the world.
Were they always shared by everyone? I mean,
yes, they were.
No, I'm going to push back
unless this, and this is what I was going to say, what I think is wrong with your thinking about it, when you get off into individual issues of policy, like abortion, like civil rights, that's not my definition of democracy today.
I don't disagree. I think where I'm coming from, and I think what's underlying my question is, like, we have had a set of shared values, but not everyone in the polity has had a role in constructing them, right? Women didn't vote until 1920. Black women didn't have the opportunity to participate in the political process until well after that. I mean, so when we talk about shared values, who is sharing them, right? I mean, and it is a genuine question. It's why I started the panel with that first question. Can we genuinely talk about core common values when, in fact, our models for democracy have depended on homogeneity?
Well, so I'll digress into politics of the day. And I don't do politics, but all of us, I think, believe we can do politics better than the politicians, right? If Joe, and I almost feel dirty even saying this, I've never said anything this political, but if President Biden and the Democratic Party run against Donald Trump and the Republican Party on these issues that you're talking about, you can expect that all the Republicans will vote for Donald Trump. And based on the statistics today, the polls, that Joe Biden will lose the election. The only way, in my view, politically, for the current president to win against Donald Trump now, because Donald Trump has won the past 3.5 years. He has normalized all of his conduct, all of his rhetoric into American society and America's political culture. And right now, many millions of people don't believe in the integrity of our elections. They don't believe in our democracy itself. He has won millions and millions of Republicans to that. So the way I talk about it is, he has succeeded in making this election only about which man is better to lead the country going forward, as if nothing in the past ever happened. So if you start arguing as the Democrats, well, look, you got to elect Joe Biden because of what the Republicans are doing to abortion, that's music to the ears of the Republican Party, and they're going to fall right in line behind Donald Trump.
But that got to be an opinion. That can't be. I'm sorry. That cannot be the truth. Because first of all, we got 30 million poor people who don't vote. Voting rights is not a political issue. And the minute you discuss it as that, and you don't own the fact that John Chapman said that every time we had a conversation in this country, racism and slavery was like a circle in the Constitutional Convention. I appreciate, I think you're right on a lot of things, but we're throwing around opinions, just like we're not talking about actual numbers. The numbers tell us that if 20% of poor, low-wage folk that have not voted were to vote in this election, in most states 10%, they could fundamentally shift the electorate. That's 55 million poor, low-wage voters. The problem is, we're not talking about if you get elected, you're going to get a living wage. If you did that, you would inspire another 55 million people, and you'd only need a group of them to vote. And if they did, in states like Pennsylvania, Michigan, Wisconsin, Florida, it wouldn't take but 2% of poor, low-wage voters that didn't vote to go to the polls and vote. And every time living wage, for instance, is on the ballot, it polls at 72%. But that's a core value as well. That's not Republican.
You're exactly right. You're exactly right, Reverend. And I wasn't referring to voting rights as an issue.
It's not an issue. It's a core to this democracy.
I agree.
And it's not a black issue. Because 50 million Americans have been hurt by what happened to the Voting Rights Act, not black folk. The problem is even we as black folk have allowed it to be a black issue. And as she said, there should have been an outcry from white, black, brown, and everybody on June 25th, 2013, when the Voting Rights Act was gutted. There should have been mass movements in the street, and civil rights organizations failed. Democrats failed. Republicans failed because we have not fixed that voting right, and 1,000 voter suppression laws have been pushed and passed in state. If voting rights is not core to this democracy, and it is seen as a political issue, not only is the house burnt down, it's burning, it's already burnt.
I couldn't agree with you more. My only point was not as to voting rights. My political point, although I didn't address voting rights, but my political answer to you, political, and you know this, that will not resonate with the Republican Party base.
When we did Borrow Money in North Carolina, 16% of Republicans marched with us and went to jail. 16%. We sent a Republican governor home. We sent a Tea Partier home. It's how you build. As long as we keep talking about left and right and center, that language is too puny, it's too small for this moment. I do not believe that the majority of Republicans would not join if we connect voting rights to abortion issues, to living wages, and help understand that that's a issue, but it's not just one issue, it's connected. I'd love to have this conversation with you in public.
I'm going to have this conversation in 15 seconds. This has been about institutions. It's been about fragile institutions, precarious institutions. I think the most significant threat to our democracy is not just Donald Trump, but a failure to galvanize the entire public around a core set of values about what it means to be a democracy. We have rampant gerrymandering, which makes it possible for the majority to see their wishes completely overrun by the tyranny of the minority, because these minority gerrymandered legislatures don't have to be responsive to all of their constituents. That's how you get a bill like HB 1510, which was upheld in Dobbs, the Mississippi ban on abortion at 15 weeks. It's why you get laws that continue to disenfranchise wide segments of the population. It's why you have people going to the polls for direct democracy to enshrine abortion rights, because their views are not being mitigated through representative government. They can directly register their responses. I teach young people every day at New York University, and we have to find a way to talk to them across parties, across generations, in a language that will resonate with them. It's not just that those who are under-resourced or poor are a huge voting bloc that's untapped. The young are a huge untapped resource. This election could completely turn on voters between the age of 18 and 30. And we have to figure out how to address them right now, because they are entirely disaffected, disengaged, and tired of politics as usual. And so I am so glad we had this conversation today. I will also confess, Judge, that like Neal, I was afraid to apply for a clerkship with you, in part because I had a sense of what Ted Cruz would become, and I wasn't sure I wanted to be a part of that.
That was low. That was low.
But we are not our worst moment, and I will say that. So,
But to show you what a good guy I really am,
You're the
my
best
last
guy.
comment is just going to be, we have 5 months, period.
to get it all together, we have 5 months to get it together. Okay. So, to the Kettering Foundation and the Rockefeller Foundation, thank you so much for this spicy, spicy conversation. Thank you to Judge Luttig and Neal Katyal, the very best of our society, like working on these issues every day. It's been an absolute pleasure. Even in our most fractious, we know what we're talking about, and we know the importance of these questions for ourselves and for everyone in this room. So thank you.
Thank you.